Hello everyone and welcome to this video tutorial in which I'm going to be talking you through the key case of Robinson and the Chief Constable of West Yorkshire Police from 2018, and this case is relevant to negligence in tort and specifically how we establish a duty of care in tort, and it's made some changes to how we use the Caparo and Dickman test, so it's an important case to know. Now I want to start by looking at the significance of the case and why I've done this separate video tutorial just on Robinson. If you've watched my other negligence video tutorials and the video on duty of care in negligence, you'll have noticed that the case of Robinson isn't in that video, and that's because that video preceded this particular decision. So this is an update, if you like, to that first video. So when we're looking at establishing a duty of care, hopefully you know the old case of Caparo and Dickman, which established what we know as the Caparo test for establishing a duty of care. So the first stage in negligence, we have to be sure that the defendant owed the claimant a duty of care. And to do that, we've always or traditionally used the Caparo test, which has 3 stages to it. Firstly, we ask whether it was reasonably foreseeable that the harm would occur. Secondly, we check that there was sufficient proximity between the claimant and the defendant. And thirdly, we check whether it was fair, just and reasonable to impose a duty. And I've just noted down here some of the key cases that you're probably already familiar with. So in Kent and Griffiths, it was reasonably foreseeable that the claimant would suffer more harm when there was a delay in the ambulance arriving. And in Ball Hill and Young, it was not reasonably foreseeable that the claimant would suffer a stillbirth after hearing a motorcycle accident. In terms of proximity, there was a duty in Home Office and Dorset Yacht, but there was not sufficient proximity between the police and the claimant in the case of Hill, because the police had no idea who the next victim or the last victim of the Yorkshire Ripper would be. And you can see that that case of Hill, a really important case, is used again here in fair, just and reasonable. So in Hill and the Chief Constable of West Yorkshire, it was held that it would not be fair, just and reasonable to find the police liable in negligence to the mother of the last victim of the Yorkshire Ripper. Now it's important that you're familiar with this case of Hill, and the reason I've reminded you about it here is that actually in the case of Robinson, the trial court and the Court of Appeal sort of talked significantly about the case of Hill, and they believed that Hill essentially made the police immune from negligence claims because of this fair, just and reasonable decision, and the Supreme Court talked about that. So we'll get onto that shortly. But that's what the law previously was, and it still is. The Caparo test hasn't been abolished, it's not been overruled by this new case. It still exists, but primarily we're only going to be using it for new novel negligence cases where there isn't already an existing duty situation that's been established in law. And that's what I've put here. So the Supreme Court decided that this Caparo test only needs to be used in new novel cases, and that courts should generally establish a duty by looking at existing duty situations and reasoning by analogy. Because obviously since the law of negligence has been established, since Donoghue and Stevenson, there have been lots of cases that have already established that, for instance, drivers owe a duty of care to pedestrians and to other drivers, and that manufacturers owe a duty to the ultimate consumers of their products. We know that those duty situations exist, so really a lot of the time we don't need to be going through these 3 stages. That's what Robinson was talking about. So now that we know the significance of the case, let's just have a look at the facts of the case in Robinson. And this is a nice picture of the Supreme Court here because the case did go all the way to the Supreme Court. So the facts of the case were these. We had two police officers who were arresting a suspected drug dealer. And in the course of that arrest, when they were trying to arrest this guy, they fell on top of Mrs. Robinson, who was a frail 76-year-old lady. And of course, she wasn't involved in any way. She was just an unfortunate bystander who got injured during this arrest. And Mrs. Robinson suffered injuries as a result of the police falling on her, and she was trying to sue the police for negligence. Now, in first instance and also in the Court of Appeal, the judges applied the case of Hill and the Chief Constable of West Yorkshire, that case I mentioned in the previous slide, and they held that the police were immune from liability and therefore they didn't owe a duty of care to Mrs. Robinson. And then the case went to the Supreme Court, that's what SC stands for, and the Supreme Court held that the Caparo test does not have to be strictly applied in every case, and instead the court should identify duties through analogy. So Caparo is only needed in novel duty situations. So that's what I was just talking about on the previous slide. So if there's a situation, and it's quite unlikely at this point in time, but if there's a duty situation that has never been to court before, it's brand new, it's novel, the courts have never considered whether a duty of care in negligence would be owed, then you would apply the Caparo test. Otherwise, we can just say that a duty exists because of, for example, in a manufacturer's case, Donoghue and Stevenson, we know manufacturers owe a duty to consumers. We wouldn't need to go through the three-stage test. But the Supreme Court also held that the police are not exempt from claims in negligence. In other words, there's no blanket immunity for them, like the first instance and Court of Appeal courts seem to be saying. Hill and Chief Constable doesn't give them blanket immunity, so the police can be liable for damages in negligence. So this was a really important negligence case and certainly one that you need to know. And let's look at how you would apply this then in an A-level exam. So what you need to do then in an exam, the importance of this case, is if the duty situation, let's say you're looking at a scenario and you're given a little scenario that says, I don't know, so-and-so buys a toaster and it's faulty and they get an electric shock and they want to sue the manufacturer of that toaster. In that situation, when you're applying the first stage duty of care, you don't have to go through that three-stage test from Caparo. You could just say, because this is an established duty situation, using Donoghue and Stevenson, manufacturers owe a duty to the ultimate consumers of their products. There's no need to apply the three-stage test of Caparo, and the case of Robinson and the Chief Constable supports this. If it's a completely novel situation, or let's say you really don't know whether a duty would be owed there, then you can still apply the Caparo three-stage test. But the case of Robinson, really important to be getting into a negligence answer. And of course, if you're evaluating the law on negligence, you should talk about this case, and you could argue perhaps that it simplified the law because we're not having to go through that time-consuming Caparo test every single time, that we're able to reason by analogy. So thank you for watching this video. Please have a look at my other negligence videos. So if you go onto my channel, the easiest way to find the negligence ones is to go into the playlist and then look for negligence, and you'll see lots of videos there. There's also some model answers and tips on how to answer evaluative essays as well as scenarios on negligence. If you're finding my videos helpful, please do like and subscribe because it really helps me to make new material for this channel. So thanks for watching.